Good afternoon, everyone. I'm Jeff Goreski, and today we're going to speak about controlling data costs, growth, and legal defensibility in your eDiscovery needs. A little bit about me, more because I'm over 100 years old as to why I've been doing this for so long, but I certainly have been around. I actually run the Forensic and Dispute Resolution Services for CBI, and also appointed to the Association of Certified eDiscovery Specialist Advisory Board. So I certainly have the knowledge and the awareness in the United States, Canada, and also in the EU on a lot of the new eDiscovery changes, a lot of the challenges, and hopefully we'll be able to answer a lot of your questions today through the presentation. In case anyone doesn't know, data continues to grow. It is incredible how the growth of data is happening exponentially. We understand that that also increases the eDiscovery spend. So one of the things that's key in today's presentation and in your ongoing eDiscovery methodology is how do we control that data growth? Just because it's growing, does that obviously introduce that it grows on what we need to collect? Well, there's some key elements we're going to be able to look at. As we can see as well, this is a worldwide trend. And as the world is getting smaller, we see now that discovery is no longer just North America. It is global. There are partnerships and entities and subsidiaries in multiple languages and multiple jurisdictions, all affecting eDiscovery. One thing that we can never forget is the obvious. Everyone who carries technology is a file keeper. And things are not anonymous, such as the internet. Everywhere there is data and anyone can access your data. So we're talking about everything from divorce, credit, lawsuits, litigation, profile, far beyond just the realm of your regular social media. So because that file keeper scenario is everywhere, we cannot just believe that the data involved in eDiscovery is in our file server, our email server, localized to our environment. It's extremely important to understand that and remember that as we talk about eDiscovery. One of the key things that I like to talk, and you can see this about Max Sherm, Facebook. So Facebook is in Ireland, so they actually, under the laws, have to give you back your data if you request it. So this person, this law student, Max, actually did. He said, I want all my data back. And of course, Facebook sent him back this CD with 1,222 PDF files. Not only did that cover all of his Facebook postings and information, it also covered his 234 friends. So that included everything, including GPS, so where she was when she took pictures with her iPhone and uploaded them. So it is incredible how the social media, how the technology expansion now is inclusive of data that we never thought would be discoverable or potentially relevant. Now all of a sudden it is out there, and we have to keep that in mind as we look at this volume of data for proper discovery. As we all know, there is a duty to preserve data. Now, the trigger for that duty to preserve is when litigation is reasonably anticipated. It does not already have to begin. It just has to be reasonably anticipated. How you normally start this duty to preserve, it's done by issuing a legal hold, also called a litigation hold. This is the notice that basically introduces to custodians the idea of looking for relevant or potentially relevant data and preserving those documents, both physical and electronic. That's a key thing to remember because, as you know, physical files are also part of discovery, and if they have to be scanned and introduced into review, then that would then become an electronic document for discovery. As well, the preservation protects the SI from loss or destruction while the parties determine what's relevant. So remember, preserving data is not only what's relevant, it's what's potentially relevant. When you preserve this data, you now have it in the capable hands of the reviewers and the determinators to determine what is relevant and then move that into formal review and the eDiscovery process to the other side. Now remember, if you do not preserve data, you fail to follow what is reasonably accepted on preservation, then courts have the ability to issue a number of penalties. These penalties can be financial, they can be judgments, they can be a variety of things, not only against the organization, against individuals, including outside counsel. So it is extremely important to make sure that when you begin your preservation, you even do that in a methodology that is defensible. There's a lot of good tools out there, that review tools and collection tools that also include a very good legal hold mechanism, including questionnaires and responses and confirmations. But remember, it is important to ensure that you're not failing on preserving the data. Now let's take a quick look at some of the changes in eDiscovery. One of the things that really has come out is that there is not only federal laws, there are also state and local laws, which sometimes supersede or enhance federal laws. So a few examples: the New Jersey public policy, privately held password protected email accounts, privilege is not waived. And in states of Delaware and Connecticut, electronic monitoring, you have to give notice or have signed documents. These are just two examples of some of the key things that are important to remember when you're looking at preservation. When you're looking at the challenges of eDiscovery, remember, they're not stagnant. It's a living, breathing cycle, and you have to make sure that you're complying with both federal and local laws. Now, what are the courts saying? Is there all these changes? How can all of us keep up with it? Well, Judges Peck and Shin and some others are putting some great bounds around what is reasonable, defensible, indefensible, and what is potentially spoliative, and what is, hey, go back and negotiate. We have to have some of these opinions, because if we hold to a standard that is not reasonable, then it cannot be defensible and it cannot be held by all parties. Even the Sedona Conference came out and said, courts do not expect the 5 nines of perfection like the phone company. We don't need to be, up except for 30 seconds per year. It is important to remember that perfection is not required for any matter. The courts desire reasonableness, not perfection. Now, that does not allow us to be lackluster or avoid what would be deemed as reasonable at a proper standard. So, but understand, perfection is not required. Reasonableness is not created by simply using the right tool. So, unlike Google, who believes that there's a car that's going to drive itself in real life in all situations, we understand at this moment the car is the tool, but the driver is the important aspect of running that tool. So the key elements still have to be held, even though you have the right tool. If you're not managing it and driving it and utilizing it properly, then the tool itself will not make you reasonable, it will not make you fully defensible, and it may not even be accurate. So the tool will only enhance what the attendant process can be. So what are some of our best practices? First of all, we want to look at how do we implement a repeatable, documented, defensible procedure and get buy-in from team members. One of the key things that we have found in eDiscovery, and you may find that yourself, is you might think something is well-defined, well-documented, well-defensible, but the other key stakeholders and team members may not be able to concur with that. As an example, somebody may believe that when litigation is reasonably anticipated, let's freeze the entire email server, every message, capture it all for every user. You might think that that's reasonable, or legal may, or some departments, whereas IT, backup, storage, networking, may say that is completely unreasonable. We can't concur to that. So it is critically important to make sure that you have buy-in from all team members. A little later on in the presentation, we're going to dig a little deeper into this about buy-in. When we start talking about bring your own device, when we start talking about cloud, when we start talking about repositories that may not be owned by the organization, how do we continue to get buy-in by all team members for doing procedures that are defensible? Remember, having a clear understanding of where we're starting gives you a better understanding of where you're going. Now, defensibility. One of the key elements to defensibility, if we remember back a few slides, we talked about reasonableness. And you're going to hear me say that quite a bit through the presentation. Defensibility with reasonableness is what was done. So what were the steps that were taken on your preservation, on your eDiscovery, on your collection, on your review? And then was it done in a way that is reasonable? And did the process produce defensible results? So in other words, was there a lot of false positives? We were looking for diamond, but we brought in baseball diamond, where we were really looking for diamond ring. So were our results defensible? We were looking for J. Goreski, and we brought in J. Goreski and J. Gronsky. Were they defensible productions? Did we produce responsive documents with reasonably high recall and high precision? Now let's talk about that. Responsive documents means documents that are potentially relevant to the matter. Doesn't mean that they're the smoking gun. It means that they're potentially relevant. With a high recall. So a high recall, did we get a good amount of data? We had 17 million messages in the mail server. We brought back 12 documents. Is that a high recall? We brought back 17,000 documents, and they were all relevant with good responses and good information. Is that a high precision? So you always have to look. We all understand it's never the light bulb, it's the guy with the ladder that costs all the money. However, you have to have a high enough recall so that it makes reasonable sense that your searching and your gathering and collection of data was reasonably responsible. And you have to also look at a high precision. Are we accurate enough in our search terms, diamond versus diamond ring, that we are capturing what we need, but are we general enough that we are also saying sofa is a chair, is an ottoman, is a table? What do we need for precision and that recall? All of that is around the defensibility. And again, not 100% perfection, but it has to be reasonable. So if we look at how do we do that, we really need to look at a proactive approach to eDiscovery. So we need to do it in a way that we're not just responsive to every single action and starting from scratch every single time. We need to be proactive. Use what we've used already, figure out what we have in our quiver, figure out what technology we are currently using, and how that technology can be brought together using eDiscovery tools and methodologies that are uniform across our repositories. So if we leverage a comprehensive data store, a methodology where all of our data or the majority of our systems can work with our eDiscovery tools, techniques, and training, we are going to help be more proactive. Now, all of you are young. I'm old. I was in the lab last week, and I received a server device, which we had to forensically image and prepare for eDiscovery. It had Windows NT on it. Now, everybody around me, of course, are young. They weren't born when Windows NT was around. So I was the one that had to show them how to work in DOS and Windows and act with no driver and no USB support and old style hard drives. How are we going to forensically, defensibly collect the data and be able to bring it in to the review repository and process it for eDiscovery? So as you can see, if you have all of your technology that can be utilized by your eDiscovery tools, your eDiscovery trained individuals, and your eDiscovery methodologies, you're going to reduce costs and improve the process of eDiscovery. We also want to look at enforcing retention policies and legal holds. We have to be able to enforce the rules that are governed by the organization. When there is retention requirements, these have to be maintained. These have to be enforced. If you are supposed to hold something, hold it. Don't determine, oh, we didn't want to hold it because it's a specific user. You need to be able to do it in a routine, uniform, independent fashion. The joy of that is you're going to potentially be able to reuse some of that held data in multiple matters. And I'll give you a couple of examples a little bit further in the presentation. We need to provide transparency and real-time reporting. One of the key things I find in eDiscovery, as we all know, from the moment litigation is reasonably anticipated, the clock starts. And it doesn't matter whether it's the meet and confer, whether it's an imposed regulatory deadline, whatever the cause is, civil action, whatever it is, there is a timeline that you have to meet. If you cannot provide the transparency and real-time reporting of how your eDiscovery is going, you will never be able to meet those deadlines. You may run into a situation where you're missing a deadline and a sanction is imposed, or evidence is excluded, or there is a ruling of some nature towards the other side, or your costs escalate because you need more reviewers, more legal assistance, whatever the case may be. So it is important to ensure that you have proper reporting, proper project management throughout the eDiscovery process. Perfect example, somebody had to go and do a collection. Somehow they believe IT is the greatest department to go and do collections. I believe it's not. However, this one particular organization did. until I'm standing there and I see of the target, and he's got his arm around him. He happens to be a nephew of the target. And I'm asking, how can you possibly go and defensively collect from this target when you're related? It doesn't fit. So by the time they got it figured out, they almost missed their deadline. The extra cost it took to get somebody else to go and collect, train them on how to do it, train them on the process, almost made them miss their deadline. Proper project management, proper organization will ensure that that doesn't happen. And consistent workflow. How often have you seen eDiscovery where you're doing a collection, a process, a batching, a review, an interaction with legal, outside counsel, interaction and negotiation with the other side, getting search terms and custodians and privilege all lined up. And you normally do it in a consistent manner, and all of a sudden this different type of case opens and everybody thinks we have to drop what we've always done and look at it a completely different way. That's not the case every time. You have to ensure you're doing consistent workflow. Data comes in, data is held, collected, batched, processed, reviewed, produced in a consistent workflow. The minute you start changing that, you increase costs, you increase your capability of missing deadlines and being indefensible. As well, the one thing that's, again, critically important, maintain a chain of custody on all of your processes, on all of your evidence, on all of your methodologies. It's the only way to ensure reliability and defensibility. We start talking about these best practices, let's get a little deeper. Recycle data. I'm working with an energy company right now, and they bring out a total of 1,985 custodians over 278 matters. When I call through the list of custodians and I match it to the date ranges of the matter, we bring it down to 133 custodians in their appropriate timeline. So imagine they had custodian A, 2010 September, 2011 January. Same custodian A on a different matter, 2011 February, 2013 June, and on and on. When you combine it, you get it down to the right number of individual custodians. You collect once, and you can reuse that data and recycle that data into multiple matters without having to perform additional collections. Critically important to look at the beginning of every matter on recycling data. Also, reducing data down. Imagine that there is a matter today that involves the IT custodians, and you take a look and you list them out, and nobody from HR reviews that to determine that 12 of the known IT custodians have not worked for the organization for the past 4 years. And the matter is only 2 years old till now. So ensuring that you have this beautiful little triangle at the beginning of every matter, this little tiger team meeting, IT, HR, legal. It's critical to be able to look at these three elements at the beginning of every matter. Imagine if legal believes all the data is relevant for the past 2 years, and in this meeting, IT is able to say, hang on, we only have data going back 12 months on these specific applications because they're old, we don't use them anymore. The data was corrupted, undiscoverable. There's a cost issue. We have to look at proportionality if the other side demands it, et cetera, et cetera. Reduce the data, recycle the data, reuse the data as often as you can. This happens mostly and most effectively at the beginning of a matter with this little triangle tag team meeting, IT, legal, and HR. We also have to look at proper project management. It is critically important to track it from time, to track independence, so that we don't have the nephew of a target attempting to do a collection, so that we know which repositories we're going to use and what language the repositories are in. It's a big world that got a lot smaller with the internet and with the transfer of electronic data. I have been involved in a matter where a particular document has French, English, and Cantonese in the same document. How are you going to review it? How is it going to be batched? How is it going to be culled down using some good automated methodologies? These are key elements that you need to come under in the beginning with proper project management. Finally, we're going to talk about vendors. In today's world, the vendors are no longer as passive as they were years ago. With the multitude of repositories, languages, versioning, techniques, vendors in the eDiscovery space have to be extremely creative, proactive themselves, and technologically advanced to be able to handle a multitude of data repositories, data types, data languages into one tool. They also have to be able to describe their limitations clearly up front. How many vendors that talk about capturing email and processing email can really do live exchange capture? Not backups, not PSTs, live real-time exchange capture. How many can actually connect to OneDrive, which is the newest part of technology, without knowing every username and password and be able to search and collect? There are limited vendors that are possible to do this. Working with either an IT consultant, an eDiscovery firm, such as a CBI, or your vendor to ensure that their tools and methodologies are meeting your checklist of repositories is critically important. And you may be working with multiple vendors. As I said, the ones that can do all of them are extremely small. They are there, but small. Again, recycling data. The motto reuse, reduce, recycle applies to all serial litigation. I mentioned earlier, similar custodians, themes, or documents need to be combined, reused, reorganized. There's a lot of synergies. There are a lot of ways to reproduce that data. And it's going to save you substantial amounts of time and money and add to the defensibility of matters when it comes to reusing data. Why go back to the well every single time? So critically important to reuse that data. Again, timelines are so critically important. We talk about antagonistic relationships between corporate legal and custodians. So it is important to have proper project management. The couple, the man worked for an organization, was able to work from home sometimes on his personal computer and VPN in. There was a snowstorm, he was sick, whatever the case may be. Ends up getting divorced. For some reason, as part of the separation, the wife gets custody of the computer. 6 months later, there's a matter. Potentially relevant data is on that computer. That computer is no longer in the care, custody, and control of the employee. How do you manage collecting from that device? There's a methodology. There's a process. There's also potentially a hurdle. You need to have that proper PM management up front so that you can identify these hurdles, identify how you're going to come up with a solution and the timeline that it takes. You ever tried to collect from a cloud provider? You ever said to Google, I know the mail's older than 7 days, it's all been deleted, but I really need it back. I need a log of everybody who accessed the cloud for the past year and a half. You can't get that automatically. You have to issue a subpoena potentially. How well does that go over? How long does that take? It's important to know all of this up front and ensure that you've got the right timing, that your legal department is aware, and that they're able to speak to this to the other side, to the courts, to the interested parties, and ensure that you're following a proper timeline. Again, driving up costs is something we do not want to do. We want to reduce costs. So the wrong path is expecting custodians to cooperate because you have deadlines. That is not going to happen. And if those custodians are third-party providers, if those custodians are terminated, disgruntled, angry employees, if those custodians are just repository owners that feel that it's overwhelmingly burdensome for them to restore every tape for the past 4 years and recall them all from the storage, off-site storage location to be able to do that and mount them all on VMs or servers they don't have, all in a short timeline, these are not the proper ways to minimize costs. So proper PMing is extremely important. Organizations out there, eDiscovery firms, offer templates and methodologies and training to help coach you on setting up these proper PM methodologies and checkboxes to ensure you're moving forward. Finally, vendors. I've mentioned this before. There is limited amount of vendors that have the capability to handle every single repository you have. Matter of fact, I would hazard to say there's not one. Having said that, for a lot of organizations, the majority of your repositories can be handled by one of these extremely powerful eDiscovery application or hardware vendors that can actually provide you with the ability to issue legal holds, questionnaires, do your mass collections, including file systems and off-site collections, bring it all into one application that can then cull it down, sort it, do some analytics, provide batching and review, and produce. So it's key to find that type of vendor initially, and then for your other repositories, make sure that you're working with vendors that understand how to integrate some of those oddball repositories, the ones that are still using btrieve, the ones that are maybe a Unix-based, an AIX, an AS400, a myriad of others, Mac. So how do you bring that kind of data defensibly and logically into a good review tool so that you're not duplicating review efforts? You still have the ability to deduplicate and provide proper culling these are important factors for selecting a vendor. Again, a lot of times it's important. I work with a federally recognized organization across the U.S. that all I did is I helped them provide a proper template for selecting their vendors, and then vetted those vendors, and then got the ones approved on the approved list for the vendors that they could select based on what they needed to do. So again, it's important to make sure that in your quiver, you have the right vendor at hand. You have a vendor that is continuously advancing technology and working towards the new modern things that are coming out. Having said that, still understand the potential of a Windows 2000 or 2003, Exchange 5.5, group-wise, first-class mail, some of the different technologies. Won't go back as far as Windows NT, but you get the drift. One of the things I hear a lot about is best of breed. You know what best of breed really is? It was an acronym brought out for a dog show. And best of breed is for a specific type of dog, not the best dog overall in the world. So best of breed, does it mean that the best of breed vendor for forensic imaging is also the best of breed vendor for review? It does not. So the best of breed words and phrases, I'm not really a fan of. What you want to make sure of is that you work with a vendor, you work with technology, you get your people trained for the methodologies that you need to simplify your discovery process. So is the tool, the training, and the technology selected reasonable in light of your needs, your proportionality, your right fit, your law firm? What happens if you work with a technology and your outside counsel says, I can't ingest that. There is no way that we can review all of that without you converting everything. That is another example of the cost being the person with the ladder, not the light bulb. So make sure that your best of breed is reasonable for you. Let's talk a little bit about BYOD and cloud. This is extremely important. As you all are aware, and I know I'm preaching to the converted, but it's critical to talk about this. Bring your own device is so popular now. You allow potentially every member of your organization to have potentially relevant data to a matter on their mobile device, on their personal laptop that they bring. How do you have care, custody, and control of it? How do you maintain governance of it? How do you collect from it when the user says, hang on, I've got all my personal emails and my personal contacts and my personal data on it, and I'm not going to allow you to touch it? How do you handle that? What is your term of use policy? What is your code of conduct? What are your rules? A lot of things that we work with organizations on go far beyond the technology. It is the methodology for handling these new challenges that are critical to a successful and cost-effective e-discovery methodology, as well as the cloud. You know, the cloud, we compare it to electricity in the early days, right? Manufacturers clung on to water wheels and because they feared power outages, and that went until electric power peers ran away with the competition, and water wheel people went bankrupt. The cloud is becoming a commodity. It is here to stay. It's not going anywhere. We have to adapt to it. But how do we adapt to it in a defensible, discoverable way? How do we maintain what we need for care, custody, and control of our data in the cloud? Again, there's a lot of technology out there that can help. Certainly a consultative approach to figure out what your needs are is critical, and that can be accomplished. Finally, one of the key elements that we can look at is predictive coding. Now, there's predictive coding, there's transparent predictive coding that a vendor came out with, which is incredibly good. But one of the things that you want to ask yourself is predictive coding defensible? Well, let's talk about it. One of the opinions came out is that predictive coding has been in place, does anyone know how long? Since 1987. You know what it was called? Antivirus. We came out against the Vienna virus, BurnFix was the company, back in 1987. Antivirus, anti-spam has been out since then. You know what that is? Predictive coding. So it is an acceptable methodology, provided it's done right, provided it's done reasonably. So it is important to make sure that any type of predictive coding, and we talk about this, diamond, baseball diamond, diamond ring, it's critically important that predictive coding is done in a defensible manner, providing that high level of recall and high precision. Extremely important. Now, if you get it right, what does it give you? It gives you huge savings. Imagine savings of 90,000, 390,000, 2.2 million. It's incredible the amount of savings that you can come up with through review and the entire eDiscovery process for predictive coding. Again, proper methodology, proper training will give you proper savings. At this point, ladies and gentlemen, I want to thank you all for attending today. We certainly would like you to reach out to CBI and for more information. Again, from a consultative point of view, a technology point of view, and a methodology point of view, there are many strategic ways that you can minimize cost, improve defensibility, and mitigate risk in an eDiscovery process. Ladies and gentlemen, I thank you.